grateful to have you on our team here. Thank you. I want to bring in criminal defense attorney Janet Johnson, too, to just dig in a little deeper to some of this. Janet, it's so good to have you here on set as opposed to via Skype as it usually is. Yes. Let's talk first. I want to get your assessment of the allegation that the free investigation was incomplete and that it was flawed. Is there credence to that criticism?
To me, it seems like they're hiding behind the whole institutional problem. If it's flawed, if there are people who are afraid to speak up, it's because of this whole silence that's been imposed at Penn State. The idea that even the custodians were afraid to challenge. They said it's like challenging the president of the United States to go against the football program. So I think if they try to say, look, there are a lot of people who wouldn't talk to you, they're kind of using their own institutional, problem to say it's incomplete. That seems unfair.
Okay, well, can the internal investigation be used against Curley and Schultz in their cases?
Well, I don't think that the findings have any, that doesn't go to, not in a criminal court of law, but I think that the emails, if they weren't already available to the prosecution, there's so many emails that are smoking guns at this point saying, here's the downside to not going forward. Other children could be victimized. That's really compelling. And if that comes in, that's a problem, I think, for the defense.
Sarah was saying that the Attorney General had asked the free investigators to stay away from certain people.
Right.
Why would that be? Was it because of the trial, or would there have been another motive?
Well, if you're thinking there's a cover-up, that would certainly be problematic. The problem with McQueary's testimony, Mike McQueary had some inconsistencies. He was off by a year, according to the Free Report, and his allegations. He initially thought it was 2002 when he saw this incident in the shower. So one of the concerns sometimes is the more time someone says something under oath, the more times they commit to their story. Right. That's impeachment in a future trial. And it could be they just didn't want their witnesses to be questioned repeatedly before they went to trial. They give fodder to the defense to say, look, McQuary's testimony was controversial, and this would give them more contradictions to then harp on.
When I was talking to Jean just a second ago about the university and how they've been so contrite and how do negotiations work when somebody comes in and they're going to offer you money, because they have reached out to victims. They have said, we want to reconcile this.
Right.
How do you determine, though, in a case like this, who gets what?
Right. Right. Well, one of the interesting thing is there are only a couple of victims that were offended at Penn State. So the question, that's a really smart question, because how are you going to then trace back to these other kids through the Second Mile Foundation, which isn't Penn State, but if Penn State had done something, would they have not been offended? That's going to be a formula that's going to be hard to figure out. Those kids, that wasn't Penn State's responsibility, but had they blown the whistle even back in '98, maybe it wouldn't have happened.
Or even in 2001.
Right.
And that was my next question. We know of at least 4 victims based on the trial and what he was convicted of. 4 victims who would not have been victims had something been done at some point in 2001. Right. How much liability does Penn State hold?
Well, not only that's tremendous, but there's an email that says, if we go this humane approach, they called it humane, talking directly to Sandusky and trying to get him to change his ways. If we take the humane approach, the only downside, this is what Graham Spanier, the president, said, the downside I see is if there are other problems in the future, are we then on the hook for those problems? That's the smoking gun. I think that's the problem for the state.
We've been talking too about Graham Spanier, whether charges will be brought against him. This happened back in 2001. But because it went on, in a sense, for 14 years, does a statute of limitation apply?
Well, there's a 10-year statute of limitations, is my understanding, for this failure to report. So it was February 2001. This is one of the issues with the Schultz, Curley trial, is they said it was 2002, so they were okay. Now the Free Report says no, it was 2001 when this incident took place. So Graham Spanier technically could be outside the statute of limitations, which might be why there was a little bit of delay in this report getting put together. If they can try to grandfather him in, I'm sure that they're going to try to do whatever they can to bring him to justice.
All right, interesting to know. Janet Johnson, it's so good to have you here. Thank you. I want to tell you about a homicide detective.